Hello everybody, good evening and welcome to a live Q&A hosted by myself, Martin Salvo, Senior Immigration Lawyer and Registered Migration Agent at Salvo Migration. And for those of you, I suppose, that aren't aware, we are the migration agency that support this specific Facebook group. So in order to, I suppose, give back to the community, we're hoping to host these live Q&As on a weekly basis. So the intention is to go live every Thursday night at 7 p.m. And for about an hour or so, I hope to be able to answer your questions live in these types of posts. I can see that there's already some questions coming through. What I'll just ask, guys, if you can just confirm for me that you can hear me. I don't want to just be sitting here waving my arms and moving my mouth if you can't hear me. So I'd appreciate it if you could just let me know quickly. And then we'll move on to the questions and we'll get, I suppose, the Q&A started. So there might be a bit of a delay from when I speak in terms of when you're hearing or seeing the video. But look, what I'll do is okay, I can see now that people are starting to see my comment and I'm getting some feedback that they can hear me. Great, okay, let's get started, guys. So first question is, Daniela, ordinarily I'd be able to pop up your question onto the screen. For some reason, it's not letting me do it in your case, but you've asked who can witness your relationship. So I suppose just to clarify, there's two types of documentation or forms that you would need to have signed to some degree. And the first is your own relationship statements. So just to clarify, you have the relationship statements that you and your partner write. So these are your relationship statements. And one's written by the applicant and the other one is written by the sponsor, the Australian partner. Now, these relationship statements, these love stories, need to be signed by the person that's making that declaration, by who's completing that form, writing that letter. Now, these signatures don't need to be witnessed. So I'm just clarifying. That may not have been your question, Daniela, but I'll just quickly kind of cross that off and address that. So there's no need for those signatures to be witnessed. I think more likely what you're asking is in relation to the Form 888. Form 888. And for those of you that don't know, Form 888s are a very important supporting document for any partner visa application. That's equally applicable to the 820, the 309 or the PMV 300. And FYI, guys, I'm actually running out of ink because for those of you that don't know, we actually hosted a live training event, a 3-day Partner Visa Secrets live training event last week. And I did this basically for 3 days. Taught, drew on the whiteboard and explained concepts, conceptual things and theory and legal requirements. And then we moved on to the practical side. And we also hosted Q&A throughout the week as well, addressing questions that popped up during the training sessions. And I ran out of ink, or I'm starting to run out of ink. So that's, I suppose, how much writing was done in that week. And I'll explain at the end of this video the next intake dates of when we're going to be hosting the next Partner Visa Secrets Live. But I suppose back to the question. Daniela, if you're asking me who can witness the Form 888s, in all honesty, the simplest and most comprehensive answer I can give you is on page 1 of the Form 888. It has a list of occupations that can witness signatures. There was another question asked, I'm not sure if it was in this thread or in another thread in the group, that asked, does the witness need to be an Australian permanent resident? Now, the form doesn't state that the witness needs to be an Australian permanent resident. It just says that the witness needs to hold certain qualifications or fall within one of these occupations. And I believe the question was that of nurse, a permanent resident nurse. I don't have any issues with a permanent resident nurse witnessing the signature on a Form 888. But Daniela, I hope that answers your questions. Just have a look at page 1 on the Form 888. It lists all the approved occupation, the qualification requirements for those that are going to witness the Form 888s. Just a follow-up question. Sometimes people ask, how many Form 888s do we need? There really isn't a maximum, and there really isn't a minimum, unless you are applying for the partner visa and you need to satisfy additional requirements. Let's say if you're unlawful or you hold a bridging visa and you're applying under that ground or on that status. In that case, you're going to need a minimum of 2. But in practical terms, you're going to need a minimum of 2 anyway, because that's what's required on the IMI forms. You're going to need to give the details of 2 Form 888, I suppose, witnesses. And so I suppose that's the simplest answer. You're going to need at least 2, but legally, there really isn't a need to have any minimum. So let's say minimum 2, maximum as many as you can get. I would say on average, our clients typically get anywhere from, 4 to 8 Form 888s. You want to get them from family and you want to get them from friends. And I had a question sent through to me on Messenger during the week asking me if it's okay for family and friends to complete these Form 888s. And my answer was, of course. I mean, that really is what the Form 888's for. It's a statutory declaration template, issued by the Department of Home Affairs, specifically for the purposes of a partner visa. And they want to hear from your friends and family. They want to see that your friends and family know that your relationship is real, and they give their reasons why they think it's genuine and why they think you are in a married or de facto relationship, or why they think you have an intention to marry, for those that are applying for the PMV. So Danielle, I hope that answers that question. Feel free to ask later on if that wasn't clear. This was the question. So Skyster, you asked, can a PR registered nurse witness the Form 888, or does it have to be a citizen? Like I said, there's nothing that's specified on the Form 888 that says it can't be witnessed by a permanent resident, and I wouldn't have any problems, I suppose, including that as part of our evidence if we were preparing that application. So I wouldn't worry too much. Melissa, hi Melissa. Melissa's asked, Martin, thank you very much for your time. If I'm under a student visa, I want to apply for a temporary one with the intention of applying for a partner visa. What happens with my student visa if the temporary visa is not granted? So just working through this, and let's just see if I've understood your question as well, Melissa. I believe that you're probably asking me, you are on a student visa, and I'm assuming that has a particular expiry date, and you're asking me, can you apply for a temporary visa whilst you hold the student visa, and what happens if that's refused? I believe you are referring to the Graduate 485, which is the most common subsequent temporary visa that's applied for by student visa holders that meet the requirements for the graduate visa. But I suppose what I'm about to say, it doesn't matter what temporary visa you're going to apply for, the effect will be the same. So when you apply for the temporary visa, let's say it is the 485, you'll be issued your bridging visa, okay, the bridging visa A. And if you are waiting for the decision on the temporary visa after the expiration of your student visa, you will be on your bridging visa when that decision is made, okay? So if the temporary visa is granted, then you just go onto that visa. So let's say it's the 485. If the temporary visa is refused, then yes, we have possible complications, because what will happen is your bridging visa will cease within 28 days of that refusal. And unless you appeal this decision, firstly, your bridging visa will cease, and so will your entitlement to stay in the country lawfully. But secondly, if you've had a visa refused and you're inside the country on a bridging visa, you're subject to what's called Section 48. And look, I suppose we're getting into quite technical areas of migration law here, so I'll do my best not to keep this, or not to make this too technical or too boring, but I think it's important that we kind of cover the whole flow of how this typically plays out. So you've had let's say a graduate visa or a temporary visa refused, you're on a bridging visa, you're subject to Section 48. Now, what Section 48 says is that you can't apply for another visa from inside the country, except for a certain list of approved visas that can still be applied for onshore if you're subject to Section 48. Now, thankfully, partner visas are one of the type of visas that can still be applied for onshore if you're subject to Section 48. So in effect, Section 48 won't necessarily apply. I suppose that's the simplest way to explain it. You can still apply for the partner visa. However, one thing you have to be absolutely aware of is if you're applying for the partner visa, when you are not on a substantive visa, so you are not on the 485 or you are not on your student visa, and you're applying whilst you hold a bridging visa, we have to look at what's called Schedule 3. Schedule 3 criteria. And more or less, you have to be able to show, and this is just simplified terminology and a simplified summary, you have to be able to show that there's very, very good reasons for the partner visa to be granted to you. You need to show compelling and compassionate circumstances. Now, there isn't any legal definition of what compelling and compassionate circumstances means. It is always very unpredictable. We find that if there are biological Australian children of the relationship, that may be sufficient grounds to waive Schedule 3 and to still have the partner visa granted. But even then, there's no guarantee. So I suppose the answer to your question, Melissa, is if your temporary visa is refused, yes, you can still apply for a partner visa, but it's going to be much more complicated. So I suppose my advice is just be sure that you are applying for the correct temporary visa whilst you hold your student visa, and ensure that that isn't refused. I mean, do everything you can to make sure that's prepared correctly and that you meet the requirements. I suppose my other question, or something that just comes to mind, is have you considered applying for the partner visa whilst you still have the student visa? Now, whether or not you should do that depends entirely on your relationship facts, and it depends on what the facts of your relationship will be when the visa is applied for, when the partner visa is applied for, which is what's called time of application criteria. Now, I talk about that in a lot more detail in a video, in a partner visa secrets video, which you'll be able to find on our YouTube channel. The title of the video is Why You Should Never Rush an Australian Partner Visa. In that video, I talk about time of application criteria. So just something to consider, in that what might be the better option is to apply directly for the partner visa whilst you still hold the student visa. If you feel that there's risks or you have concerns about this temporary visa being granted to you, but you do have to factor in time of application criteria for your partner visa and make sure that you meet the requirements for the partner visa when you apply. These are really the sorts of topics that we go into in a lot more detail in our live training event, which, like I said, I'll talk about at the end of this video in terms of when we'll be hosting that again. I hope that answers your question, Melissa. Daniela, finally I can get your comment up. So yes, perfect, great. Glad that I answered the question and that I interpreted your question correctly. Sherry's asked, hi Sherry, one of our original members and one of our most keen followers. So nice to see you, Sherry. Hi Martin, my partner previously sponsored his wife 25 years ago and can't remember the date that he initially applied for her visa and the date it was granted. Can you help us? What would be the best thing to do with that? You can request information from the department. It's called applying for a Freedom of Information request, an FOI request. I can't recall the form number off the top of my head. However, if you go to Google and you type in FOI request or Freedom of Information request form, you'll see that there's an official department form that can be completed, and you can request this type of information from the department. You may also be able to request it directly from the partner visa section by emailing them directly, providing your partner's passport details and Australian citizenship details. If he has any access to previous reference numbers, that would be helpful in being able to identify that previous application, and the department may be willing to give you that information without necessarily needing to go through the FOI process. The issue is that with the FOI process, it doesn't cost any money, but it can be lengthy. It can take many, many weeks. And especially with COVID, anything to do with the department, any administrative kind of task, any administrative process is taking much, much longer than what it used to. So that would be my two pieces of advice, or my two suggestions, is look into the FOI form and submit an FOI request, or email the department directly with references to the previous application. At the end of the day though, if you can't remember the specific date or details that your partner sponsored his ex and it was 25 years ago, the application won't be refused because you've given an incorrect date. That information can always be amended later. I would suggest that you attach a supporting letter from your partner just explaining that he can't recall the specifics. And that way the case officer knows that you're not trying to mislead them, and you're not trying to withhold information. It's just that the information's so old and you just don't have access to that at the moment. So those would be my 3 suggestions to address that issue. Hi Karen, how many pages is a good relationship statement? There isn't an official length of relationship statement that would be perfect. Every couple will be different, and every person is different in terms of their writing, I suppose, capacity, how comfortable they feel expressing their feelings. The only thing I can say is, we do have this resource, which is our Partner Visa Relationship Statement Guide and Template Pack. Inside you'll find, I think there's over 10 examples of relationship statements that were written by previous clients of ours. Of course, we've changed names and dates and we've removed any sensitive data. But in all honesty, if you want a resource that helps you write your statements and you want references to how others have written it, that's really the best option. To give you a rough estimate, I would say, on average, clients write anywhere from 2 to 4 pages, depending on the font size. But it's not so much about the length of the writing. It's more about what you say. It's more about making sure that you talk about the progression of the relationship, how you met, how it progressed, where you see it going in future. You speak about the aspects of the relationship. You talk about any periods of separation. That's really what the statement is for. It's not to write a lengthy love document. It's to talk about the criteria of the partner visa and address the aspects of the relationship. And again, detailing the aspects of the relationship and what they actually mean is something we talk about in the live training, which again, I'll explain at the end of this broadcast where to go and when the next intake will be. Hope that answers your question, Karen. Sherry's asked another one. Also, is it all right if we apply for a partner visa a week or 2 before my tourist visa expires? Yes, there's no problem. As soon as the partner visa is submitted, the department systems will issue your bridging visa and your acknowledgement letter. So because it's all digital, as soon as you press submit, you put your credit card details in or your PayPal details in, you hit submit, the emails come through pretty much instantaneously. Sometimes there's a small delay depending on what's going on with the department systems at that point in time. However, it really shouldn't take more than a few hours. So you technically have up until 11:59 p.m. on the day that your visa expires. So if your visa expires on, let's say, the 1st of June 2020, you have until 11:59 p.m. on the 1st of June to submit your application. That being said, don't do that. Do not wait that long. Sometimes there's maintenance on the department website, the IMI forms, and you're locked out for hours. So I would say, to be safe, always look to apply for your visa a few days before or a week before. So there's no problems with applying a week or 2 before your tourist visa expires. It's very normal. It's important to utilize the time that couples have left on their current visa to maximize their facts, to strengthen their evidence, to make sure that time of application facts are as strong as possible. So it's about finding that balance. But sure, a week before your visa expires, no problems. Patty, one of our regulars. Hi Patty, yeah, you can. The replays will be available in the group. We'll probably set up a particular tab in the group where they'll just be stored and they'll be there forever. So no problems in watching this tomorrow or over the weekend when you get a spare few minutes. Hi Olga, nice to see you again. Okay, so Sky says asked another question. Thanks, man. I do have one more question. Travel history. I have traveled extensively, 25 countries and some of them. Sounds like you had a great time. I'm very jealous. Multiple entries. I've gathered most of my travel info, but in some cases I couldn't find the exact dates of departing and returning. Very normal, very normal. Particularly for people from the EU, where they're coming and going regularly, and people that work in the tourism industry or the cruise industry. Often, they have a very detailed and extensive travel history. Do I just not list the countries I don't have the exact dates, or do I write the date that I believe is as close to the real travel date as possible? The safest answer to that question is give the most accurate possible estimate that you can and list all of the countries that you can possibly remember that you've traveled. your visa will not be refused because you've got a date wrong in your previous travel. In the 10 years that I've worked as an immigration lawyer and agent, I've never seen a partner visa refused, or any visa refused for that matter, because an applicant couldn't remember the date that they entered Guatemala, 9 years ago, and they just remember the month. That's fine. The department have to be, I suppose, accepting in at least your attempt to provide them the information. The reason that they want to know your travel history, there's a few reasons, but one of the main ones is they want to see how long you've spent in particular countries. Because if you've accumulated more than 12 months in a particular country in the last 10 years, then they'll probably request a police clearance from that country. So that's, I suppose, a bit of context in terms of why they ask you for your travel history. It also ties into background checks and making sure that you're not someone that could be a danger to the country. But typically that seems to be why the information is requested, or at least what the practical impact is. It's really, they're looking how long you spend in countries to determine if you need a police clearance. So just give your best estimate. These questions pop up really commonly when clients start completing Form 80s or Form 1221s, which are often requested for partner visas, and in fact the things that we suggest that applicants complete in advance. And those forms are very detailed. They are a pain to complete because of all the information they request. And we approach those forms the same way. We say, look, fill these out as best as you can. Don't worry if you don't remember particular dates or names. Give the best estimate and account of your history as you can. And if needed, we can always explain that down the track, but no problems in you giving them close to the real travel date as possible, to answer your question. Nafis, hello Nafis, thank you for your question. Hi Martin, do we need to highlight the transactions on our bank statements? Would appreciate your answer. You don't have to highlight the transactions on your bank statements, but it is advisable because you have a case officer that, let's put this into context. There's 50,000 partner visas submitted to the department and various consulates and embassies every year. So your application is a number. The case officer does not care about you or your relationship. They don't care. They have so many applications to process. The department are receiving more and more applications every year. With COVID, processing times are going to take longer and longer. They're going to be under more pressure to process applications faster than ever before. So understand the context of where your application sits. Now, if a case officer receives two very similar applications, and one provides bank statements and the other provides bank statements, and one provides bank statements that are highlighted, and the case officer can see rent, groceries, utilities, holiday, travel, we bought a car. Of course, as a human, the case officer will look at that application differently to the application that just has a bank statement with nothing highlighted. It also draws the case officer's attention to what you're trying to highlight. You're trying to show that you're pooling your finances. You're trying to show that you're using your pool finances for the living expenses of your relationship, which ties into the criteria of the partner visa. It ties into you showing that you are in a de facto or married relationship, or that you intend to marry if you're applying for a PMV. So although there's no legal requirement that you highlight your transactions, it's certainly advisable, and it's not necessarily something that needs to be done in all cases. It's really a spectrum. How much effort do you want to go to? How much of a chance do you want to give your application? How much easier do you want to make the case officer's job? That's really what you're trying to do. You're trying to make their job as simple as possible. So just give them everything, highlight it, be really organized, and you're just going to make their life easier, which will just naturally affect the way they approach the rest of your application. And also, like I said, it highlights what the transactions are for, and it draws their attention to the criteria and your particular facts. Hope that answers your questions, Nafis. Thank you, Martin. Great help, as always. No worries, Sherry. Happy to help. Shoma's asked a very interesting question. Hi, Martin. The processing times for PMV have been updated as unavailable due to low volume of applications. Do you reckon this is good news or bad news for applicants? Look, I'm not going to say that it's good news. I think what I'm going to say is that we don't know exactly what's happening internally with the department and the consulates. What we do know is that with COVID, only those that are granted permission to travel or approved, the 309 or the 820, are permitted to travel automatically. Anyone outside of those types of partner visas, such as prospective marriage visa applicants or prospective marriage visa holders, still need permission to travel. So as far as we know, the PMVs are not necessarily being processed. That doesn't mean that they're never going to be processed again, and it doesn't mean that you can't apply for them. It just means that they're just sitting wherever they're sitting at the moment. So the department website saying it's unavailable due to low volume of applications, I think is a misleading statement, and I think it's inaccurate. It's not because there's a low volume. I think it's because they've just put it on hold and they can't give us an estimate at the moment. And that's the only text they had available to say. They either say a date or they say unavailable due to low volume of applications. They don't say not processing due to COVID. They're not going to cause that type of panic. But in my opinion, that's what's happening. It's just, they're just putting things on hold. So it's not good news, Shoma, but it doesn't mean that it's terrible news. It just means that there's going to be a delay. But in my opinion, there's going to be a delay irrespective of the type of visa that is being applied for to this country. Even onshore 820s and offshore 309s, so the non-prospective marriage visa offshore applications, will be delayed. So I think everyone's in the same boat. So I wouldn't look too much into that statement on the department website. I know it's been spoken about a lot. I've received questions in relation to that as well. But that's our position at the moment. Unfortunately, there really isn't an official announcement from the department. We're kind of just interpreting based on what we're seeing and speaking to members of the industry and other colleagues, etc. Hope that answers your question to some degree, Shoma. I'm sorry I can't give you a solution. Unfortunately, we just have to kind of wait until COVID goes away and things go back to normal, which hopefully isn't too far away. Krills. Hi Martin, thank you so much for all this information and your time. My question is it better to get married here in Australia then apply to bring my partner visa over, or marry in the PNG and apply offshore to bring my partner here, then apply? Hope that makes sense. Okay, so Krills, I suppose whether or not, I'm just rereading the question just again to make sure that I've understood it correctly. Is it better to get married here in Australia then apply to bring my partner over, or get married in the PNG and apply offshore to bring my partner here? Just making sure that what you're asking me is, should you apply for an offshore partner visa or should you apply for an onshore partner visa? So where you get married, let's just work through this. Where you get married doesn't really make a difference. When you're applying for a partner visa, whether you're married in the PNG or if you're married in Australia, as long as it's a legal marriage or a recognized marriage in the PNG, in PNG will be recognized here. So where you're married isn't really the issue. If we're talking about should you apply for the offshore partner visa, or should you get married overseas and apply for the offshore partner visa, or should you bring your partner to Australia, get married and then apply for the onshore partner visa? I hope that's what you meant. Depends on what your plans are, depends on your intentions, because there's a big difference between the two. The main difference is that if you apply for an offshore partner visa, your partner doesn't have an entitlement to come to Australia and stay in the country for a long period of time whilst you're waiting for the offshore application to be processed. Compared to if your partner comes to Australia and you get married and you apply for the onshore partner visa, your partner is issued their bridging visa and it keeps them in the country lawfully until the decision is made on the partner visa. So I suppose it depends what your plans are. If your partner has a need or a requirement to stay in the PNG for the next couple of years, and this does happen, and we are approached by couples that are overseas and they say, Martin, what should we do? And this is really what we open with. We say, well, when are you looking to come to Australia? When are you looking to bring the partner here? If you want to bring the partner here quickly, then don't apply for the offshore partner visa, because it's going to take a very long time. And looking to get them in and apply from onshore is the quickest way. Under normal circumstances, let's assume COVID isn't an issue and there's no travel bans, but under normal circumstances, getting the partner here on some type of temporary visa, such as a visitor or tourist visa, and applying onshore, let's say after a marriage, may be the better option, because it gets you together sooner and it keeps the applicant inside the country. They're entitled to stay, they can work, they can access Medicare. So, what works depends on your particular needs and what you guys are planning to do for the next year or two. So I hope that answers your questions, Krills. My apologies if I've misinterpreted, but I believe that's what you were asking me. If I've misinterpreted, let me know in the comments and I'll go back to it. Pat's asked, hi man, can we get our IT guy to complete the Form 888? The issue is we only met him in April this year. There's no minimum requirement in terms of how long you've known the person or how long the couple's known the person that's completing the Form 888. So it doesn't matter that you've only met this person in April. I would say though that the longer that someone has known a couple, the more weight that Form 888 will hold to a case officer, to the department. But in terms of legally speaking, and it being a valid Form 888 or being a valid piece of evidence, there's no issue with having met someone earlier or recently and them completing the Form 888. I hope that answers your question, Patty. That would be my simplest answer to that question. Olga's asked, if I got a bridging visa A, no conditions, which will be issued, then my current tourist visa expires. Will I get work permit automatically? Okay, so just to make sure that I've interpreted this one correctly, Olga, I think what you're asking me is, you are currently in Australia on a visitor visa, on a tourist visa, okay? So there might be a lot of you in this position at the moment, so hopefully this helps you as well. So you're in Australia on a visitor visa. And that visitor visa will expire, let's say, on the 1st of July 2020, okay? And you look to apply for a partner visa before the expiration. Okay, you apply for the 820, 801, and this has a bridging visa linked to it. It's a bridging visa A. I believe what you're asking me, Olga, is when will you have work rights? Or when will you be able to work? So it doesn't matter if you apply for the partner visa here, or here, or here, or right 9:59 p.m. on the expiration of your visitor visa. Your bridging visa will only come into effect, meaning it kicks in, is the simplest summary, from 12:01 a.m. on the 2nd of July 2020. So from this point onwards, you have nil conditions and you can work. Okay. So I suppose the question is, well, Man, what's the point in applying here or here? Why shouldn't we just wait up until the end? That way we maximize our time together and we strengthen our facts and then we apply. Yes, that's certainly one way to look at it, and that's something that I talk about a lot in other videos and again in the training that we'll be doing next month, is making sure that your time of application facts are as strong as possible. And one strategy to do that is to utilize the time you have left on your visa before applying. On the other hand though, sometimes couples have different priorities, and another priority might be Medicare. So as soon as you apply for the 820-801, you can go to Medicare and you can get cover. So sometimes couples weigh up the two. They say, yes, we want to maximize the time we have left on the existing visa before we apply for the partner visa. That's a sensible thing to do. But on the other hand, we want Medicare for various reasons, especially at the moment. It's a very interesting time in the health system. So it's understandable people want security and safety of the medical system being there available to them. So they weigh it up. They say, we want Medicare, but we don't want to jeopardize our partner visa by applying too soon. And they pick a date that feels comfortable to apply for the partner visa. But like I said, Olga, to answer your question again, it doesn't matter where you apply, your right to work will only kick in from 12:01 a.m. on the 2nd of July 2020, which is the day after your visa expires. Okay. Obviously, this is just a made-up date. Your visitor visa may expire sooner or it may expire later, but just giving you, I suppose, the formula of when you have nil conditions. Okay. Aaron, hi man, how do I approach the relationship statement the fact that I applied for my student visa knowing that I was going to apply for my partner visa. Because of my student visa statement, I said I was going to study and go back to my country. Aaron, people change their minds all the time. And what you've given the department as part of your student visa application doesn't necessarily have an impact on the partner visa application. And it's very common for international students to apply for an extension of their student visa by renewing and applying for another student visa. They provide supporting documentation in relation to that application and meeting that criteria. And then a few months later, they decide to apply for a partner visa. You are within your legal right to apply for a partner visa if you have a student visa. For me, there's no need to address your previous student visa application in your relationship statements. I feel that they are just completely irrelevant to what the purpose of the relationship statement is. The purpose of the relationship statement is to outline your relationship, your history, your milestones, as I've said before, where you see it going in future, and talking about the aspects of your relationship, the aspects of your household, your cohabitation, how do you live together, how do you pool your finances, the social areas, do your friends and family know about your relationship, and how committed are you guys to it. Again, if you want to know how to write the perfect relationship statements, get this guide. I promise you won't be disappointed. But don't talk about your student visa in your relationship statements. I don't feel that it's relevant. I hope that answers your question, Aaron. Suma. I got refused a tourist visa as I'm from a high-risk country and they believed I would not return to my country, especially as my wife lives in Australia. Sue, that's a very common issue with visitor visa applications, meeting what's called the genuine temporary entrant requirement, or being able to show that you intend to stay temporarily and go back home. And sometimes that's an absolute coin flip, and particularly from people, for people that come from certain parts of the world and high-risk countries, very unpredictable when it comes to visitor visas. We've now applied for the Offshore 309 and we want to reapply for another subclass 600. How do we prove I will return to my home country as I have no property or business in my home country? There isn't any official way to prove that you intend to go back, but I suppose some suggestions that I can give you is the shorter length of stay that you request on your visitor visa may have a bearing on the ultimate decision. If you request a very long period of stay, that may cause the case officer to be suspicious of your intentions. And how long do you want to be here? Are you really coming in here to stay temporarily? If you want to be here for 12 months, well, maybe not. So requesting a shorter period of stay. How long you should request specifically, I can't give you the specific answer because that doesn't exist. It's absolutely discretionary. The other thing I can suggest is you can provide, if not a return ticket back to your home country, at least a tentatively booked itinerary with a travel agent that shows that you have a booking or a reservation for a flight to depart the country at a certain point in time. Whenever I suggest this to couples, I always say, look, speak to the travel agent, see if there's a fully refundable fares that are available or fully flexible fares that might be available, just in case if your visitor visa is still refused, even after doing this, you can get your money back on the fares. So that's, I suppose, two tips that I can give you to maximize the likelihood of you being accepted for the visitor visa. But unfortunately, there's no guaranteed method, Suma. What I will say though is that, yes, you've had a visitor visa refused, but the fact that you have a pending offshore partner visa sometimes is enough to tip the scales in your favor when you're assessed against the genuine temporary entrant requirement. Again, showing that you intend to leave, because you need to leave for the 309 to be granted to you. And sometimes case officers will use that and weigh it up and say, yes, she tried to apply before, this was refused before. However, now circumstances have changed. They now have a pending offshore partner visa. She needs to depart the country, or they need to depart the country. We feel that they're not a risk of overstaying and we're going to grant the visitor visa. So to some degree, I think that you've already done what you can. The big thing that you can do to show that you're going to leave is have a pending offshore application, which you have. So perhaps if you try again for the visitor visa and you try the two strategies that I've given you, requesting a shorter period of stay and providing evidence of your return flight, then that might be enough in combination with the pending offshore application. I hope that answers your question, Suma, and helps, and all the best, if you do choose to reapply for another visitor visa. Olga's asked, how long do I usually have to attach documents after sending my application? Look, partner visa applications will process for many, many months, okay? So theoretically, you have many, many months to upload your supporting documentation because it's just not going to be looked at by a department case officer. However, the best practice approach, or at least how we do things with our client applications, is as soon as we apply, we upload the documentation. Just in case, in the random event of a case officer picking up an application and seeing no supporting documentation and making an arbitrary decision just to refuse because nothing's been provided. I haven't seen that happen in my experience, but you can never fully predict what a case officer or the department will do, and you want to minimize risk as much as possible. So my advice, Olga, is try to attach your documents within the week of uploading your application and submitting your application. But really the safest way to approach it is attach your documentation immediately after. That way you've removed all risk. The other thing to factor in is as your application is processing, every few months, continue to update your evidence. Provide more cohabitation documentation, more financial pooling, more photos of you and your partner surrounded by friends and family. If you've purchased things together, upload those receipts because you want to strengthen the application as it's processing. That will help speed up the processing period with the department and will also ensure or reduce the likelihood of them requesting documentation in future, which again speeds up the processing of the application. That's the one thing that can delay applications the most, is department case officers requesting additional relationship evidence. So you can avoid that to some degree, or try to avoid that by continuing to update your evidence as you go. So to summarize my answer to your question, try to attach your initial set of evidence as soon as you can, and then continue to update your evidence periodically after lodgement. Okay, Melissa, I'm just clarifying your question. So you've asked, hi man, I meant the temporary tourist visa as an option if I cannot continue affording my tuition fees for now and my student visa expires in 2022. Okay, I understand. I want to apply for a partner visa this year, as you explained on another YouTube video. A reminder of my original question, if the tourist visa is not granted, what happens with my current student visa? Okay, short answer, nothing. If you apply for the visitor visa and it's refused, that has no implications to your student visa. Having a visitor visa refused doesn't lead to the cancellation of a student visa. What leads to the cancellation of a student visa is breaching your conditions, not going to class, not paying your fees, poor academic performance, and the school cancelling your COE and reporting you to the Department of Immigration. That's what leads to student visa cancellations. If you've applied for a visitor visa and it's refused, as long as you abide by your student visa conditions, it won't have any implications. So I suppose that's the simplest answer to your question. Thanks, Melissa. Karen's asked, thank you for your help. How is the best way to organize the proofs of relationship, photos, messages? Karen, I suppose the most comprehensive resource that I can eventually point you in the direction of that helps with the organization of your relationship documentation and evidence is Visi, which is our DIY partner visa custom built software, which we talk about at our live training that we will be hosting next month. So at the end of our most recent live training, we presented Visi and certain packages to people that were interested in using the software to prepare their application to those that attended. And we intend to do the same for the next intake. So as part of Visi, one of the features is really our document checklist, which is the most comprehensive document checklist you'll find anywhere. And that explains how to organize your documentation. Plus it has heaps of other features built in. If you're interested, go to veazy.com.au, veazy.com.au, and have a look at what's included in the software. But like I said, we only accept or issue licenses to those that attend our live training. So, that's really the best resource that I can point you towards that helps with the organization of your relationship evidence and documentation. Joseph. Hi Man, is there any method of applying for a visitor visa that we can lodge and be able to apply for a visa extension so that we can apply for bridging visa, etc.? I'll just reread that one, Joe. Hi Man, is there any method of applying for a visitor visa that we can lodge and be able to apply for a visa extension. So we can apply for a bridging visa. I'll try to answer this. Again, just trying to interpret what's being asked. When you apply for a visitor visa from onshore, bridging visas are automatically issued or connected to the visitor visa. So you don't apply for the visitor visa, the bridging visa separately. It's part of the application of the onshore visitor visa. If you're asking me, can you apply for a visitor visa from offshore, and are there bridging visas associated to offshore visitor visas? The answer is no. There's no bridging visas associated to offshore visitor visas. If you're asking me, can someone come in on a visitor visa and then extend that visitor visa and apply for another visitor visa? My general answer is yes, that can be done in most cases. It depends on the conditions that are imposed on the first visitor visa. For example, if there's a no further stay condition imposed, which prevents a subsequent application, unless you apply to remove that condition, you won't be able to extend or apply for any other subsequent application from onshore. So, Joe, I hope one of them or a collection or combination of those answers answers your question. My apologies again if I've misunderstood. Please feel free to ask again if I've missed it. Just to let everyone know, we'll probably go for another 10 minutes or so. So we'll probably wrap things up about 8 o'clock Australian Eastern Standard Time. Hi Kaylee, when applying for the 801 visa, one section asks about our finances, relationship, etc. 4 of them. Are they statements, or we will write proper statements later? Are they very important, or are they just general letting them know we met financial, etc.? So if you're asking me on the application form, more or less, the application form mirrors the typical structure of a relationship statement. So what we often, I suppose, suggest to couples is you need to do one or the other. You either need to address the 4 aspects of your relationship in the application form, or you need to do it in your relationship statements, and you then need to refer to your relationship statements on the application form. So you do need to address the 4 aspects. The other thing as well is with the 801 or the permanent application, there are official statutory declaration forms that need to be completed by the sponsor and applicant, or should be completed by the sponsor applicant, I should say. So if you have a look, Kayla, if you Google 801 stat decks, sponsor and applicant, you'll find them. You know, they're government forms. They'll be somewhere within the department website, and in those stat decks, it asks both the applicant and the sponsor to address the 4 aspects. But like I said, the applicant, in some respect, addresses those 4 aspects in the actual application form. So there's multiple areas that you can talk about the 4 aspects, but you do need to talk about them. So it's not just a general conversation in those forms. You do want to be talking about them. What I will say is, I mean, you've already had the temporary partner visa granted. Really what the department want to see now with the permanent is that you're still together. You know, they want to see that you are still cohabitating, that you're still living together like a married or de facto couple. So whatever was provided to the department for the temporary application just needs to be updated and refreshed now that you're, I suppose, addressing the 4 aspects again now for the permanent application. So I hope that answers that question, Kaylee. So guys, I know there's some of you asking questions, but for some reason it's not allowing me to pop up the question on the screen. So if you're not seeing me answer your question, it's not that I don't want to, it's just that I can't actually add it to the screen for whatever reason. A bit of a technicality with the software that we're using, unfortunately. So Sky says asked, I do have one more question in regards to previous relationships. I was with my ex-partner for 6 years from ages 19 to 25. I'm now 31 years old. We did live together for a couple of years, but I don't feel we were de facto. And we didn't pull finances together at all. How important is this question really? Should I list my ex-partner as de facto just in case? Really common questions, guys, there. Whenever we're talking about department forms and what to declare or what not to declare, our position as a company, as an agency, and I suppose this is how this is the same way that we guide our own clients when these questions pop up for our own clients, is we want to be as conservative as possible with the department. And we want to reduce the likelihood of a department case officer deeming that we've withheld information or misled them in any way. So just understand that principle. Now we're talking about, was your previous relationship de facto? Did it meet the requirements of de facto? There really isn't an official answer to that question, because the definition of de facto is complicated. It's, there's several factors, there's several aspects that define whether or not someone's in a de facto relationship when we're talking about Australian immigration requirements. So really, you should be applying the same criteria to assessing that previous relationship. Were you pooling your finances? Were you cohabitating? How long were you together for? Were your friends and family aware of the relationship, etc.? And you make that judgment call. In my opinion, it's always better to over-declare than to under-declare. And I would prefer that couples declare previous relationships. It's not going to jeopardize your application by declaring. Let's put it that way. You being in a relationship for 6 years ago has no impact or no bearing on this partner visa application with your current partner. Of course, assuming that your relationship with your previous partner started after the previous relationship ended. So understanding all those factors, I would probably suggest it's safer to declare because you can't over-declare. You're just reducing the risk, and you're approaching things conservatively. And I feel that's the best way to approach any question in any government form or any Department of Home Affairs form. So I hope that answers your questions, guys. So short answer, I would probably suggest it's best to declare. Joseph, hi Martin, is Vietnam a high-risk country? Now, when we're talking about the definition of low-risk and high-risk countries, the simplest way to look at it is if the visa applicant or the passport doesn't entitle them to apply for an ETA or an e-visitor, one of those very quick, simple online style visitor visas, then it's more or less not low risk. Okay, so they're not low risk if you can't apply for those types of visas. Vietnam, and as well as that, there isn't an official list in department policy when we're talking about partner visa applications that says applicants from this list of countries will be deemed high risk for the purposes of a partner visa application. So there isn't an official resource or an official list of countries that are deemed high risk for partner visa cases. So understand those two points. My partner has been here before. We have been in a relationship for over 8 years. Should we state in the next visa application that we intend to apply for an 820 and which visitor visa allows her to stay? Does this make sense? We just want to be together sooner rather than later. So, Joseph, with the visitor visa criteria, and just to explain, with a Vietnamese passport, I'm quietly confident that the only visitor visa they are eligible for is the subclass 600, which is, let's say, the manual visitor visa. I can't recall off the top of my head if Vietnamese passport holders are entitled to the ETAs or the e-visitors. I suspect not, but you'll have to just double check that. But if they're not, then the only visitor visa that's available is the subclass 600. Now there's different streams under the subclass 600, but if you're looking to get her to enter and apply for an onshore partner visa, you want to be applying under the general tourist stream. The reason being is that the other streams have a higher likelihood of a no further stay condition being imposed. Whereas the general tourist stream, it's a discretionary decision and they may not impose a no further stay condition on a subclass 600 visitor visa that's applying under the general tourist stream. So that's hopefully answers your question in terms of which visitor visa should you be applying for. In terms of should you declare your intention to apply for an onshore partner visa, it is a bit of a contentious issue there because part of the criteria for a visitor visa, irrespective of the stream, is that you intend to stay temporarily and then you're going to go back home. That's typically how they're assessed, and why they're most likely refused is because applicants can't show that they intend to go back. However, there is government policy which in some way governs the decisions of department case officers, and it's more or less their guidelines and how they interpret the law. And in that policy, it does state that department case officers can assess visitor visa applications leniently even if there's a declared intention to come in and visit an Australian partner and potentially apply for an onshore partner visa. And basically what the policy says is that the genuine temporary entry requirement isn't about preventing people from applying for another visa from onshore. It's about preventing people from entering who may be at risk of overstaying, so coming in and staying illegally, or coming in and working illegally or breaching their visa conditions. So, that government policy is designed to, I suppose, interpret that a little bit more leniently. And they say, look, if there's an Australian partner, if the relationship can be evidenced to some degree, if there's supporting documentation that shows that the applicant won't be coming in to overstay and become unlawful or come in and work, such as a supporting statement from the sponsor that says they're coming in, they're going to be living with me, we're looking at applying for an onshore partner visa, which means she won't go unlawful, or I will make sure that she goes before the visitor visa expires. And I can tell you, Joseph, that we have applied that strategy multiple occasions, and it has been successful when pointing out that policy to the department case officer. So I feel that not all case officers may know that that policy exists. So if you are going to apply for a visitor visa with the declared intention of applying for a partner visa onshore, you need to bring that policy to the case officer's attention. Of course, if you're looking for a bit of assistance with that process, feel free to reach out, Joe, and I'm happy to provide you more information. And I think that wraps up all of the questions. We've just, Suma snuck in one more question before we finish up, guys. So this will be the last one for tonight. This will be a weekly thing. So every week we'll go live and I'll answer these types of questions. So if I don't get to you today, just hold on to your question and feel free to ask in the group at any point, and we'll always do our best to answer them in written format. But we do want to address questions this way as well, which I feel is a lot more comprehensive and a lot more interactive, and I suppose creates a better connection with our community. So Suma has asked, when front loading, is there a specific button to press to say you have front loaded? No. Or is it just a matter of uploading everything so they don't need to request more information? By the way, thank you so much for giving us your time. Heart made of gold. Heart, debatable if heart's made of gold, but happy to help the community where we can. There is no official button that says this is a front-loaded application. The term front-loaded is a made-up word. It's not an official government term. You won't hear case officers say in their approval decisions or in their request letters or any official correspondence with applicants, they don't anywhere say anything about front-loaded applications. So just assume that doesn't exist, because it really doesn't. What you're giving them is a thoroughly prepared application and something that evidences the relationship well. And that will always help the case officer's job and speed up processing and ultimately increase the likelihood of an approval. So there's no button. Yes, you just want to upload everything you can that evidences your relationship. And by doing that, and by continuing to do that periodically whilst the visa's processing, continue to update your evidence and attach more documentation that ties back into the four aspects of the relationship, you will reduce the likelihood of a request for more documentation. You can't guarantee that there won't be a request, but you certainly reduce the likelihood. What I can tell you, Suma, is that that's really the strategy that we approach for our own client applications, and 99% of them do not get requests for additional documentation. The only thing that our client applications typically get requested are medicals and police clearances, because we don't organize them until they are requested so that we prevent them expiring during lodgement for our clients. So we understand there's a lot of costs involved in applying for partner visas, and if you sit your medicals too soon in the process, or if you organize your police clearances too soon, they might expire and then you need to do them again. So to avoid that, we typically suggest to our clients that we're going to evidence everything else. We're going to continue to update your application whilst it's processing, but we will wait until they ask for your medicals and police clearances. And by doing that, we find that our applications are, typically go through without requesting any more relationship evidence. So I hope that answers that question, Suma. Thank you everyone for attending tonight. What I'll say quickly before I forget is there's a bit of look, it doesn't matter now, but this is just a bit of a bio in terms of who I am, who's Martin. I'll make these slides available in the group so you can get, I suppose, a feel for who we are as a company and what we stand for. This is just a bit of information about me personally. Mandy is our other senior immigration lawyer who is involved in this group as well, so you'll see her pop up. I'll also link to our partner visa approvals and reviews booklet. Now, this booklet contains over 40 examples of approved partner visas that we've secured for our clients. I don't put that here necessarily to try to persuade you to engage a lawyer or to pressure you to engage a lawyer. I put it there simply to show you that we know what we're talking about when it comes to partner visas, and hence why I feel that I can sit here and answer your questions confidently and accurately. So that'll be linked in the group after this stream ends. So for those that want to have a look through the partner visa approvals booklet, feel free to have a look. You've already asked your questions. And now, this is the next confirmed dates for our live 3-day Partner Visa Secrets training. So if you've enjoyed this Q&A session, this is one component of what our live Partner Visa training 3-day event is. So like I said, we hosted our most recent event last week or a week and a half ago. We had over 500 attendees. Every night we went live and we taught. I taught about the conceptual requirements for partner visas. So we gave our attendees information about what the law is and what that really means, what it really requires for you to meet partner visa criteria. And then we spoke about the more practical side of the actual partner visa preparation process, documentation, forms, the waiting periods, what you can do, tips and tricks, how to save money with the department, etc. It goes for 3 days. The group is actually open for a week, and every day we go live, and then the day after I go live during the day answering questions from the training the night before. So it's a very comprehensive and intense period of learning, but it was so well received that we've decided to do it again. Even though it was exhausting, I think it was something truly positive, and the feedback was overwhelmingly positive. So we've locked in the next round of training. It's going to be on June 22nd. I will link the group at the end of the stream, and you're welcome to all join the group. Everyone will be let in the day before. So June 21st, we'll let everyone in. If you attended the last Partner Visa Secrets live training, you're more than welcome to attend again. Okay, so hoping to make it bigger and better. We received feedback from the last training, and we're already putting and implementing suggestions that were provided and feedback that was given to make this Partner Visa Secrets live training even better than the last one. So that's the information. I'll link the group to join after the stream ends. That's it from me, guys. Martin Salvo, Senior Immigration Lawyer, Migration Agent at Salvo Migration. If anyone wants to get in touch, please feel free to go to our website, salvomigration.com.au, or you can shoot me a message on Messenger. I may not get to it straight away. Messenger isn't our official channel of communication. It's just a way to connect and have an initial conversation, but then eventually, we'll bring you over to our more formal methods, booking phone calls and speaking directly, to talk about your case specifically. So hope this helps. I'll see you guys next week.